Good evening, members. I, Dr. Secretary, Bangalore branch, on behalf of the management committee, welcome you all for this study circle meeting on private trust and succession. We have CA.BHARADWAJ S as the speaker amongst us who will present his paper on the subject. May I call upon Chairman Sir, CA Manjunath to escort the speaker and present him with the floral bouquet. Members, it's my proud privilege to introduce today's speaker, CA.BHARADWAJ S. The speaker is born to a couple chartered accountants in 1992. He completed his secondary education in Bangalore and his higher secondary education at St. Joseph Pre-University College, Bangalore. He pursued his articleship in Burma and Burma Chartered Accountants, qualified as a chartered accountant, and also took bachelor's degree in commerce. He took a bachelor's degree in law from the Karnataka State Law University in 2018 and obtained a scholarship for securing the highest marks in criminal law. He practiced as a chartered accountant between January 2015 to October 2018. He enrolled as an advocate in the year 2019 and has been in legal practice since then. He started appearing before the Commissioner, Income Tax Appeals and the tribunals at the very age of 23. He presently practices before the authorities, tribunals, the appellate authorities under the income tax as well as indirect taxes. He also appears before the High Court of Karnataka. He also has matters pending before the Supreme Court of India and Madras High Courts. He has reported orders of the High Court of Karnataka and the Income Tax Appellate Tribunal to his credit. His areas of practice extend to drafting as well as consultancy in the matter of relating to commercial contracts, succession, income tax laws, including personal taxation, corporate taxation and international taxation, including that of transfer pricing. He also has matters with regard to goods and service tax laws, company law matters, foreign exchange management laws, foreign contribution regulation law, etc., and some litigation prominently in the taxes. He has keen interest in writing and speaking and has multiple published technical and non-technical articles to his credit. He is assistant editor to the Company Law Institute of India Private Limited and authors headnote for their journals in income tax, GST and company law matters. He has co-authored the third edition of the book The Trust by C.R. Rao, published by Pugliani and Pugliani, where he authored the part of taxation of the trust. He enjoys public speaking and has been engaged in professional and other organizations including the Bangalore, Udupi, Davangere, Ernakulam branches of the Institute and CPE chapters of the Institute of Chartered Accountants of India to speak on the select technical subjects. He has also been invited to judge moot court competitions such as the prestigious Surana and Surana National Corporate Law Moot Court competition at the JSS Law College, Mysore. He is a member of the Central Tax and Corporate Law Committee of the Federation of Karnataka Chamber of Commerce and Industry. Outside the profession, he has deep interest in Carnatic music and is generally curious about in-depth field of knowledge. Today we present before you the speaker, Bharadwaj S.
Namaskaram. My thanks to the managing committee of the Bengaluru branch for having invited me to speak here today. They have invited me on a few occasions in the past. My only complaint with them is on every occasion I am invited to speak either on charitable trusts or on private trusts. And I am worried that I am being typecast. There seems to be a perception that I only know these two fields of the law. I do not claim to know anything. But if they believe that I know this, then I claim that I know one or two other things also. But anyway, it is their discretion. I am also happy to see a reasonable turnout for a subject that I do not consider particularly popular, because it is somewhat a specialized field, and many CAs are of the misconception that it is a field which is more appropriately populated by lawyers. As somebody who has feet in both waters, I can tell you that there is sufficient scope for professional practice for chartered accountants in this field too. There are three reasons. So I was asked to speak on trusts in general, and this particular topic I selected. There are three reasons I selected this subject. Actually four. The first is that I recently spoke on it, so it makes it easier for me to not spend too much time preparing again. But the three reasons I picked this subject are as follows. First, so far as the law of succession is concerned, I think there is a significantly untapped professional practice for chartered accountants in that field. In my experience drafting wills and in succession planning, I find that the utility that a client sees in drafting a will is more in terms of inventarizing assets than in terms of the succession itself. This is particularly so in the case of high net worth individuals and individuals who own substantial immovable property. A couple of years ago, I was drafting a will for a woman who owned whose estate was about 200-300 crores, and because the will had to comprehensively cover all the immovable properties, I sought title documents of the property so that the descriptions can be precise. And only when I went through those documents did she realize that she owned 2-3 pieces of property which she didn't know about in the first place. Similarly, so far as movable assets are concerned, it is advisable for people who are in the twilight of their lives to consolidate movable assets into a few avenues simply to make succession management easier and simply to facilitate easier handling of these properties upon their demise. So when even the very task of getting information from the clients is actually ultimately useful to them, because typically you'll end up with one Excel sheet which has all of the assets, and even Schedule A in the return of income doesn't seem to serve this purpose completely. The second reason I picked this subject is because this concept of trust is not very well understood, not just in chartered accountancy but also in the legal profession, and regrettably to some extent even in the courts. The reason for this is that the foundational principles of what constitutes a trust are somewhat complicated. And I have said this on this stage before. Once those foundational principles are clearly understood, everything on top of that is fairly simple. The third reason I have selected this subject is because on the subject of succession, CAs tend to be a little reluctant to approach it because of what they perceive as their own ignorance of the law governing succession. I will therefore give a brief overview of the law of testamentary succession so that you can equip yourselves to be a little more confident in that field. So these are the three reasons. These are also broadly the three sections in which I will be dealing with today's subject. I have never spoken at a lecture and finished the whole syllabus which I intended to finish. So I will begin with that disclaimer. I apologize for that in advance because I am sure it is going to happen today too. Let us begin with the idea of what is a trust. Let us assume that I own a piece of immovable property and that there is some person who is unauthorizedly occupying that property. He has encroached it. The remedy for an encroachment is to secure eviction. Let us say that a civil suit is to be instituted against him for eviction. The civil suit is instituted against him because he is the person who is sought to be evicted. Who will institute it? That is, who will be the plaintiff? The plaintiff will be me, because I enjoy legal ownership of the property. In the law, you can either be a person or you can be property. Virtually everything else in the law is only descriptive of the relationships between persons inter se, the relationships between persons and property, and the relationships between property inter se. So, for example, the concepts of rights, liabilities, obligations, privileges, etc. are in relation to persons, and the concepts of ownership, possession, custody, bailment are in relation to persons and property between each other. So, if a particular thing exists, before I go further, I should also say the first part is fairly theoretical. I have a particular disaffection for the people who say that theory and practice are not connected. I think sound theory is the strongest foundation for good practice, and it is not, and I think in trusts, the theoretical deficiency is actually the problem. So, I own immovable property, I want to evict the encroacher. I institute a proceeding because I am the owner of the property, and there are two dimensions to ownership. The dimension of ownership that permits me to institute this proceeding is legal ownership. Let us assume I succeed in the suit is decreed, he is evicted in execution of the decree, and tomorrow I let out the same property to some tenant. The tenant pays me rents. Why am I entitled to collect these rents? Because again I am the owner of the property. This dimension of ownership is what is called beneficial ownership. So therefore, ownership for the purposes of today's discussion has two dimensions: legal ownership and beneficial ownership. In virtually every situation of ownership that you will see in the law, legal and beneficial ownership vest in the same person. The only exception to this rule is the idea of a trust. In the trust, the legal ownership and the beneficial ownership are separated, so that the legal ownership vests in the trustee, whereas the beneficial ownership vests in the beneficiary. A trust is a concept which we have inherited from the English law. If you look at similar principles in the Hindu law, you will not find actually a direct parallel to a trust. You will find things akin to a trust. For example, what is the position of a dharmakarta of a temple, or a mathadipati or a mahant of a math? In both these cases, the legal ownership of the property of the temple or of the property of the math do not vest in the mathadipati or the dharmakarta. The dharmakarta or the mathadipati are merely managers of the property of the math or the temple. On the other hand, the position of a trustee is significantly stronger than a position of a dharmakarta or a mathadipati, because he is not merely a manager, he is the owner. Therefore, hypothetically, let us take an example. There is a trust settled by X, Y is the trustee, T is the trustee, and B is the beneficiary. And there is only one beneficiary, and the whole of the trust property is held for the benefit of B. In this case, if the trust property, some portion of the trust property should be conveyed, say by a registered sale deed, it is the trustee who will have to execute the sale deed because he is the legal owner of the property. If I take the similar example of an encroachment upon the property of a trust, the suit for possession or the suit for eviction will have to be instituted by the trustee and not the beneficiary. In fact, in that circumstance, the beneficiary is not even a necessary party to the suit. In many circumstances, the beneficiary is not even aware that a trust has been settled of which he is the beneficiary. It is not an essential ingredient of the trust, either that the beneficiary be aware of the existence of the trust, or therefore, to come to practice, that the beneficiary be a party to the trustee. Now, this is the jurisprudential concept of a trust. A trust, only, to put it very simply, where you separate legal and beneficial ownership, a trust is created. We are often faced with the question, particularly in the context of taxation, or even to some extent in company law, as to whether a trust is a person. Most of us will very comfortably say that a trust is not a person. The question then is, why is a trust not a person? A trust is not a person because this is all it is. It is merely an arrangement. It is merely a form of ownership. If you want to understand the fundamental concept relating to any subject in the law, the first resource to go to is Salmond on Jurisprudence, edited by P.J. Fitzgerald. I think the last edition was published sometime in the 1960s. Everything from ownership to persons, to corporate persons, to possession, to what is law, all of this is answered beautifully in Salmond's book. Now, there are therefore three parties to a trust. The first is the person who creates the trust. The creation of a trust is also referred to in the law as the settlement of property upon trust. Therefore, the person who creates the trust is either called the author of the trust or the settler of the trust. The person in whom that settler or author reposes trust to hold the property is the trustee. The truster, so to speak, is the settler or author. The trustee is the person in whom trust is imposed. And the third party is the beneficiary, for whose benefit the trust property is held. Questions have often arisen before the courts as to whether where disputes arise in relation to a trust, can those disputes be referred to arbitration under the Arbitration and Conciliation Act of 1996. For arbitration provisions to apply, for arbitration to be available as a remedy, it is necessary that there must be an arbitration agreement. Any contract of, if you look at certain standard form contracts, you will see an arbitration clause in the boilerplate provisions towards the end, the part which nobody reads but the part which is actually important. That arbitration agreement is an essential ingredient to institute an arbitration proceeding. And if you look at a trust, there is no consent involved at all to create a contract. If you look at the essentials of a contract, mutual consent, that is free consent without coercion, undue influence, etc. That is one of the most fundamental elements of a contract. And that is decidedly absent in the case of a trust. How? First, as I've already pointed out to you, the beneficiary is not a necessary party to a trust deed. Because you may very well settle the property upon trust for the benefit of one Mr. X. X need not be aware of that settlement, the benefits will flow to him. X, of course, has the right to say, I don't want the benefits. He can renounce those interests and come to renunciation later. So the beneficiary is not a necessary party. What is even more important is that even the trustee is strictly not a necessary party to a trust deed. The trustee has a right to refuse to accept a trust. The Indian Trusts Act says explicitly that no person can be compelled to act as a trustee. Once he has accepted office as a trustee, he cannot thereafter renounce it except with the approval of the civil code, etc., which are things I will deal with later. So theoretically, if the settler Mr. S says that I hereby settle property, settle the following sum of rupees 10,000 rupees upon trust for the benefit of Mr. B, of which will be held by Mr. T as a trustee. Mr. T and Mr. B need not be parties to the trust deed at all. In such a situation, where is the question of consent? Further, when you consent to act as a trustee, let us assume that you consent to act as a trustee. What is the other ingredient of a contract? Consideration. What is consideration? Section 2 or 3 of the Contract Act is very beautifully structured because so most definition clauses in statutory enactments are arranged alphabetically. But if you look at certain older enactments like the Contract Act, you will find that the sequence of the definitions is actually logical. It is not alphabetical. So first it says what is a promise, then it says what is consideration, then it says what is an agreement, etc. So one of the ingredients of a contract is consideration. Nudum pacta, no consideration, no contract. Where is the consideration here? The trustee can either consent or decline to consent. But he is not receiving any consideration for being a trustee. He may receive remuneration, but there is nothing in the law which requires that remuneration be mandated for a trustee. the remuneration, if at all, is attributable to his performing his obligations as a trustee. It is not attributable to his acceptance of the office of the trust either. So consent is absent, consideration is also absent, so there is no contract. It is for this reason that the Supreme Court has held in a line of cases, including Vimal Kishore Shah versus Jayesh Dinesh Shah, that since a trust does not by itself constitute an agreement, disputes relating to trusts cannot be subject to arbitration. Now, if you look at Section 3 of the Trusts Act in the light of all that I have said, Section 3 defines a trust as follows. A trust is an obligation annexed to the ownership of property. Let us stop. Who is the owner of trust property? The trustee. How is a trustee different from an absolute owner of a property? He is obliged to hold the property for the benefit of the beneficiary. Therefore, a trust is this obligation. A trust is an obligation annexed to the ownership of property and arising out of a confidence reposed in and accepted by the owner. The confidence is reposed in the trustee by the settlor and it is accepted by the trustee. The next words are significant. Or declared and accepted by him. So the previous clause deals with a case where one person reposes confidence in another person, that is a settlor and the trustee. The clause I just read stipulates that one person declares that confidence and he himself accepts it. So the question is, can a settlor also be a trustee? The answer is yes. For the benefit of another. Let's start from the beginning again. A trust is an obligation annexed to the ownership of property and arising out of a confidence reposed in and accepted by the owner or declared and accepted by him for the benefit of another. So this for the benefit of another relates to the word obligation. Or of another and the owner. For the benefit of one. For the benefit one of another or two of another and the owner. Therefore, can a trustee also be a beneficiary? The answer is yes. So this is very clear from Section 3. I propose to deal with it later, but since I have touched upon this now, I will dispose of it in full. So there are three parties in a trust deed. A settlor, the trustee and the beneficiary. Can the settlor and the trustee be the same person? The answer is yes. There are two questions. Can the settlor and trustee be the same person? Yes. Let me rephrase that. There are two questions. Can the settlor also be a trustee? Yes. Can there be absolute identity between the settlers and the trustees? That is, let us say that there is one settlor, he himself is a trustee. In this case, the two are identical. Let us say that there are two settlers and they are themselves the trustees. In this case, there is identity between settler and trustee. Let us say there are two settlers out of which one of them is named as a trustee. In this case, one settler is a trustee, but there is no identity between trustees and settlers. All of this is possible. A settler can be a trustee and there can be identity between the settler and the trustee. Can the settler be a beneficiary? And can there be identity between the settler and the beneficiary? The answer for both these questions is again yes. So let us take an example. Mr. S owns immovable property. He then executes a trust deed, and there is actually a very practical need for trusts of this kind. Let us say Mr. S has been diagnosed with dementia. He is in a sound state of mind today, but he apprehends that a few weeks, months or years from now, he will not be in a position where he will be able to deal with this property. He wants to continue to retain the beneficial owner of that property, or ownership of that property. In the sense that it is self-occupied property, he wants to use it for the purposes of his residence until for the whole of his life. But he apprehends that because of his state of mind and his diagnosis, he will not be able to deal with payments of municipal taxes, maintenance of the immovable property, letting out a portion of the collecting rents, etc. So what he can do then is execute a trust, settling the property upon trust, say to his wife, Mrs. S. We will call her T because it's just convenient. Settler S, T, trustee, beneficiary. So he will settle it upon T for the benefit of himself. So in this case, a settlor is the beneficiary. Let us look at this whole thing from another angle. We began by saying that the concept of a trust is the separation of legal ownership and beneficial ownership. It doesn't matter how the separation takes place. If I am the settlor, I retain the beneficial ownership, but I give up the legal ownership. I am the beneficiary, somebody else is a trustee, I am also the settlor. I am the settlor, I have both legal and beneficial ownership. I give up the beneficial ownership and retain the legal ownership. I am the settlor and the trustee, I am not the beneficiary. So, first, can the settlor be a trustee? Can there be identity between the settlers and the trustee? Yes and yes. Can the settlor be a beneficiary? Yes. Can there be identity between settlers and beneficiary? Yes. Can a trustee be a beneficiary? Yes. Which we have already seen. I will repeat that if required. Can there be identity between trustee and beneficiary? No. This is the only permutation which is not possible, because I am the settlor of trust property. For there to constitute a trust, there has to be separation of legal ownership and beneficial ownership. Legal ownership is with the trustee, beneficial ownership is with the beneficiary. If there is identity between trustees and beneficiaries, both legal ownership and beneficial ownership are with the same person. So there is no trust. It is theoretically impossible. Legal plus beneficial is absolute ownership. Now, therefore, there cannot be identity between trustee and beneficiary. Can a trustee be a beneficiary? Still yes. If there are 3 trustees, one of them is a beneficiary, that is okay. If there is one trustee and he is a beneficiary, he is one amongst 3 beneficiaries, that is also okay. Because to the extent of that 1/3, assuming the shares are equal, there is a trust. So, this clarifies all the questions of who are the parties and in what capacities can they act. There is one more point to be dealt with in this context. There is a misconception in general that the law is only that which is written in statutes. This is completely incorrect. Many of you will be familiar with the concept of Hindu undivided families, Vitakshara law, co-partition and repartition, succession by survivorship, etc. So the sources of the law are statutory law, which is enacted or statutory law, which is enacted by Parliament or state legislatures. There is also customary law, which is what the personal law is. For example, Vitakshara law governing joint families, Marmakatayam, Alya Santana, Daya-Bharadraj, etc. We have also inherited, besides the Hindu personal laws, and to some extent the Shariat, besides these 2 laws, we have also inherited the English common law. So it is not as if prior to the enactment of the Sale of Goods Act in 1930, nobody could have ever sold goods. It is not as if prior to the enactment of the Transfer of Property Act in 1882 or the Contract Act in 1872, contracts could not be entered into or enforced, or transfers of property could not be effected. Statutes of this kind most often do not create too much new law. They only amend the common law as it exists, and they may add to it. Or they may codify what exists without amending it also. And if you look at the statement of objects and reasons of the Indian Trusts Act, it is very clear that it does not merely amend, but it also consolidates the existing law, which means the law of trusts precedes the Indian Trusts Act of 1880. More significantly, so the law of trusts precedes the Act, but the law that, to the extent that it precedes the Act, it is the English Common Law of Trusts. To the extent that the English Common Law of Trusts is not contradicted or reversed or negated by the Indian Trusts Act, the English Common Law of Trusts will continue to apply. I will come to this later because this is particularly significant. The difficulty, therefore, with subjects like trusts and subjects like succession is actually finding the source of the law. If you are able to find the source of the law, identifying the proposition involved is considerably easier. There is a decision of the Karnataka High Court directly on this point. I will come to that a little later. So the governing law in respect of trusts is the Indian Trusts Act and the English Common Law on Trusts, to the extent that it remains unmodified by the Indian Trusts Act. One more very important point here, which I think generally tends to go unnoticed, is that public charitable trusts are not subject to the Indian Trust Act. Section 1 of the Indian Trust Act deals with its applicability and specifically says that it does not apply to public, charitable or religious endowments. At least 2 high courts, unfortunately I don't remember the citation, at least 2 high courts have held that the law, the Indian Trust Act does not therefore apply to public charitable trusts. Therefore, if you are drafting a public charitable trust deed, please don't refer to the Indian Trust Act and get yourself into a spot of bother. There are various difficulties. For example, Section 20 of the Indian Trust Act lists an exhaustive number of avenues of investment in which the trust property can be invested. These avenues are actually narrower than what is specified under 11(5) of the Income Tax Act. So if you subject yourself to those provisions unnecessarily, then you are unnecessarily constricting the scope of your operations. Anyway, that is beyond today's syllabus. Having the, yes sir.
We have a few questions. Okay,
yes, please.
So, under which act do those public charitable trusts get?
There is only English common law. There is no act.
There is only English common.
Yeah.
English common act.
English common law. So let me be a little clearer on that. Charitable trusts are not governed by the Indian Trust Act. There are certain enactments in certain states, like the erstwhile state of Bombay, which is now Maharashtra and Gujarat. There is a Bombay Public Charities Act, which will apply. In the state of Karnataka, we do not have such an enactment today, and I hope we do not have such an enactment in the future. I understand, I remember that there was some bill in one of the legislatures but never came to be passed. When you say a public charitable trust is registered, what that means is that the trust deed has been registered in the sub-registrar's office under the Indian Registration Act of 1908 in the same way that you would register a sale deed. So registration of a charitable trust is either the registration of the trust deed or registration under the Income Tax Act under Section 12A or what was earlier 12A. What is the law? What is English common law? See, so this is strictly not in the syllabus, but I've been waiting for somebody to ask this question because these theoretical tangents are quite fascinating. Courts in England and the judicial process in England predate statutory law. So, if X and Y had a dispute as to the ownership of some property, where there is no statute clearly stipulating what the law of ownership is, how will courts decide who is the owner? They would apply some principles of fairness, etc. For example, possession creates a presumption of ownership. So if you prove possession for X number of years, I will say that you are the owner of the property. I am able to produce a conveyance saying that I have purchased the property from somebody, I paid consideration. Now, these courts were deciding cases based on what is called equity. Equity is something like fairness. We will not go into what is equity in depth. Over a period of time, what happened was that more and more statutes came onto the books. Then the courts found that statutory law and equity were slightly different. So the courts in England were then divided into 2. Courts of law and courts of equity. The courts of equity, and I might be wrong and subject to correction, were referred to as a Chancery Division. Even now the High Court, at least until recently, the High Court of the United Kingdom had a Chancery Division. So, over a period of time, the doctrine of judicial precedent applied in the UK even before statutory law came. So, if a particular principle was laid down by a court in interpreting a position, that principle was followed subsequently. That judge-made law became a law in itself, which is called the English common law. So that English common law is not codified, like the English Constitution itself is not codified. Article 372 of the Indian Constitution says that all laws as they were prevailing in India before the Constitution came into force will continue to apply to the extent that they are not repugnant to the Constitution. Therefore, the English common law was in force in India for so long as India was a colony of Britain. And therefore, by virtue of Article 374, English common law continues to apply in India. So there is no codified, there is no book you can go to and say this is the law on public charitable trusts. You have to study English common law from treatises. And the same is true in respect of various other fields of the law. Is that answer your question?
But I know a lot of these temples, charitable trusts, they are all
Yes.
registered under the Indian Trust Act. Only we don't even know about it.
So the question posed is that temples, charitable trusts are not registered under Indian Trust Act. Maybe they don't know about it. First of all, the Indian Trust Act does not contain a provision for registration at all. It is like the Indian Contract Act. The Trust Act says this is what a trust is. This is how you create a trust. You can do these things in a trust. You cannot do these things in a trust. But we are not saying everything about trusts here. There is no authority for registration. There is no application. There is no authority administrating that. Secondly, if you are a public, charitable or religious trust, you cannot be registered. You cannot be governed by the Indian Trust Act at all. Section 1 of the Trust Act says that. Thirdly, in the case of a temple, you have or a matha. The matha is a public institution, but in the case of temple, it may very well be a private temple. A couple of years ago, I had a case of a fairly prominent matha who came and said that, listen, we have a matha, we have a devasthana, and we want to structure all this by means of trusts. I found that very amusing, because Article 372 not only preserves the English common law, it also preserves Hindu law to the extent that it is not repugnant to the Constitution. In the Hindu law, a matha or a devasthana can be established by sankalpa and utsarga. So if you perform those functions, there is a legal obligation. Of course, the difficulty there is you may not record it in writing, etc. So there is a problem of lack of awareness of the law. But in the case of public institutions, the Indian Trust Act does not apply, so you have a little less to worry about. As I said, the problem with common law is finding the law. One principle which is there in the Indian Trust Act, which is, so most of the Indian Trust Act is the same as what the British common law said. There is very little amendment. One principle in the Indian Trust Act which is very significant, nobody knows about it, is that if there are more than one trustee, the trustees have to act together. Therefore, unless the trust deed says that a decision can be taken by majority, no decision is taken unless it is unanimous. This is the law. Now, if you do not know this, and your trust deed does not contemplate decision by majority, some troublemaker in the future who knows about this can cause problems. So it is important to be aware of the law. So having now understood the nature of trusts, we will discover that the utility that private trusts have in the context of succession is actually very limited. In my view, particularly in urban centers today, there are a bunch of companies typically associated with banks who perform trusteeship services. And typically family offices, high net worth individuals, etc., settle a lot of trusts. In many cases, these trusts are not actually required. I'll give you one example. Just about a month ago, one individual contacted me. He is worth some 20,000-30,000 crores. He has, both his parents are alive, and he has a brother who has some mental health problems. Both parents own one immovable property jointly. Very simple. They both purchased jointly, there is one sale deed. He consulted one of these companies, and so he called me up and said, I want to settle a private discretionary trust. When somebody who is not a CA lawyer, who has no practice in this field, calls and asks for things with such specific language, you know that he is getting himself into trouble. So first I asked him, why do you want a trust and why do you want a private discretionary trust? There was no satisfactory answer to that question. In his case, what already existed was, for the mother's share of that immovable property, there is a trust in which she is the settler, this man is the trustee, and the brother is the beneficiary. For the father's share, he is the settler, this man is a trustee, and the mother is a beneficiary. And there are about 4 trusts in this arrangement. For a long time I wondered why all this had been done. Imagine 3-4 transactions down the line in that immovable property, somebody does a title scrutiny and finds 5 trusts, and one of those trustees has not signed the conveyance. It will really damage the title far into the future. It appears to me, and I am only speculating on a lighter note, that this is done because that trustee company is remunerated on the basis of a fee per trust. So there is some incentive to settle as many trusts as possible. So the trusts are being overused, and at the same time there are circumstances in which trusts deserve to be used but are not used. The first justification for using a private trust as an instrument in succession, which is the main reason, is the insulation of that property from security interests. Let us say that I am a director of a company. Company has borrowed loan. Inevitably, the bank will ask for a personal guarantee from me. I own 5 pieces of immovable property. One is self-occupied. Either that one or the other 4, I will settle a trust in favor of my wife, and with me, her, and say my children as beneficiaries. In this case, I am not the legal owner of that property. So even if the guarantee is enforced, that property cannot be attached, or the funds cannot be recovered. So this is one legitimate justification for using a private trust in the context of succession. So the interests of my successors in this example are also protected. At this point, this is a workable solution. I have no basis for the following, but I find it hard to imagine that this will go on for very long. I wonder if there could be statutory amendments either in the law governing security interest, that is somewhere under the Banking Regulation Act, or possibly even FEMA, which will eventually say that where a property of a particular person is settled upon a trust only for his family, that will be deemed to be his property for the purpose of enforcing security interest. It has not happened thus far, and most people who resort to this arrangement are fairly powerful people, so it is possible that it may not happen in the future too. But as of now, the legal structure permits this. The second is the very definition of a trust, where you have some person upon whom you want to confer the benefits of the property, but who you cannot trust with the ownership, with the legal ownership of the property. A trust is a good exercise. We have advised this in cases of people with mental health difficulties, and that is broadly the largest instance of this kind of justification for a trust. There is only one difficulty with this. Very often the mental health difficulties today do not rise to the level of unsoundness of mind that will render that person incompetent to contract. Let us say that you have some mental health difficulties in which, to use the law of the Contract Act, you have intervals of sound mind and you are basically of unsound mind. Or to flip it, you have intervals of unsoundness of mind, but you are basically of sound mind. This is one situation. Let us also take a circumstance where there is no unsoundness of mind at all, but in practice you are unable to deal with the property or unable to manage it. So long as a beneficiary is competent to contract, under Section 56 of the Indian Trusts Act, the beneficiary has a right to claim ownership of the trust property. Remember that trust property is held for the benefit of the beneficiary. So if the beneficiary tomorrow decides that I want that property, he has a legal right to become the absolute owner of that property by virtue of Section 56. Therefore, in adopting this as a justification to settle a private trust for the purpose of succession, you must also ensure, ideally, and unfortunate that I have to say this, ideally if the beneficiary is unaware of his rights in this respect, the purposes of the trust will be served better. Otherwise, the risk that the beneficiary deprives the trustee of the legal ownership and takes over the property himself is very real.
So the basic purpose is depicted in Section 56. When the beneficiary can go for a legal ownership, then the basic fabric of trust is...
The basic fabric of trust is actually to secure benefits to the beneficiary. That is why Section 56 exists. So let us look at it this way. Let us assume that I settle property upon trust in favor of the beneficiary. If you don't give him this right, is he really the beneficiary? In any case, this is a discussion on legislative policy. And even if Section 56 was not there, this is the same position under the common law. So unless there is a statutory declaration that the beneficiary cannot claim ownership, that right is anyway there.
Would it be ultra virus of the trust, if I put in the trust deed that 56 may
Yes.
be
Yes.
not considered?
You can't do that. This is a very interesting question. Sir's question is, if I put in the trust deed that the beneficiary will not have the right to claim ownership under section 56, would that be valid? The answer is no. Because you cannot directly contradict the law. So that answer is very clear, but I feel compelled to point out that in certain laws, even the Companies Act, for example, and so the laws that some provisions of the Transfer of Property Act, some provisions of the Indian Trusts Act, it is permissible to, what is the term is to contract out of the provision. You can enter into a contract to say that provision will not apply. Whether you can or cannot contract out of a provision has to be understood on an interpretation of each specific provision. And on section 56, I can assure you that there is no court in the world which will uphold a provision like that, which contradicts it in the trust deed.
So if it is one beneficiary, what you say might still be okay, but if there are three beneficiaries, can one of them say, I want my share of the ownership?
Yes. I'll read section 56. Section 56 has two clauses. The first is right to specific execution, which is that he has a right to tell the trustee you have to execute the, because if the trustee is not performing his obligations as a trustee, the beneficiary has a right to seek that. Your question is directly answered. And where there is only one beneficiary and he is competent to contract, or where there are several beneficiaries and they are competent to contract, and are all of one mind. So I was wrong. If there is one beneficiary, then he may choose. If there is more than one beneficiary, then all of them have to enforce the right. So let me read that again. And where there is only one beneficiary and he is competent to contract, or where there are several beneficiaries and they are competent to contract and all of one mind, he or they may require the trustee to transfer the trust property to him or them, or to such person as he or they may die. So that answers your question. If there is more than one beneficiary, they have to act together. Merely one beneficiary asking for this right is not contemplated under section 56.
So all three of them
Yes.
have to do it.
Yes.
And all of them should be nature. I mean, competent
For
to
that.
contract.
Necessary.
If one is minor, again they can't do it.
Yes.
So you answered the question partly saying, for the first one, insulation of property from security.
Yes.
One question came to mind, and I
Yes.
think you answered it, but I'll ask it anyway. So is there any use case for a property which is owned by a person? So he becomes a settler, he becomes a trustee, and he also becomes a beneficiary. Is that first of all allowed in the Act?
So I'll answer that question, but before that I must say that let's not, in the context of laws like negotiable instruments, trusts, contract, partnership, sale of goods, no question of allowing, not allowing. It's whether it is theoretically possible or not. Trustee and beneficiary cannot be the same person, because legal ownership is with one person, beneficial ownership is with another person. Only then a trust is created. If trustee and beneficiary are the same person, legal and beneficial ownership are with the same person, that is absolute ownership. Then the third, is that clear? The third use case for trusts in the context of succession is the law on probates. I will deal with the law on probates in greater depth in a few moments. A probate is defined by the Indian Succession Act as a copy of the will given under the seal of the court. The law of probates in India is a little strange. I will not go into the historical context, but broadly, probates are required only in respect of wills which are either executed in a particular territory or which deal with immovable property in a particular territory. What is that particular territory? The limits of the ordinary original civil jurisdiction of the Madras High Court, the Calcutta High Court, and the Bombay High Court. So within in each case you will have to inquire whether the property is in these jurisdictions. So the ordinary original civil jurisdiction of the Madras High Court does not extend to the whole of the state of Tamil Nadu. So there is a category of high courts in the country called chartered high courts, which were created by a charter of the Queen or King before independence. or they were created by letters patent issued by the regime, the British regime. Those high courts, by virtue of Article 372 of the Constitution, which I have already referred to, those charters and letters patent continue to apply today. So they remain governed by those laws. If you look at other modern high courts, they are established by acts of parliament. Like for example, the most recent examples are the Telangana High Court, the High Courts of Jharkhand, the High Courts of Uttarakhand, and all of those. Now, when the Indian Succession Act and the law on probates was enacted, it was only these three chartered high courts who existed. So at that time, it was within the ordinary original civil jurisdiction of these high courts that probates were required. That law on probates remains unchanged until today. So that is the position as it continues. So practically, what does this mean? If the will is executed within these territories, or if any immovable property being dealt with by the will in these territories is in these territories, then a probate is mandatory. The Indian Succession Act says that where a probate is required, the will cannot be proved without a probate. Does that mean that in territories outside these territories, probate cannot be obtained? The answer is probate can be obtained if the state government has issued a notification saying you can obtain probates. So the position in Karnataka is that probates are not mandatory, but probates may be secured, and courts in Karnataka will grant you a probate on a probate petition being filed. The problem with probates is precisely this. You have to file a petition for a probate before the court. That will take a few months, it could even take a year. And if the property is particularly valuable, there are typically, so how is a probate petition dealt with? The court will receive the petition and say, okay, this is the will. The court will not go into whether the bequests are legal, whether the executor is valid, whether the property is actually owned by the testator. The court will not examine all of this. The court will simply examine whether the will was executed, whether anybody disputes the will. So it will publish, there will be a public notice saying a probate is being sought in respect of this will, you have so many days to object. Typically, if the property is very valuable, there will be busybodies who will want to object and say, and thereafter lay claim to that property saying my grandfather's granduncles have owned that property, so I need a share. So this is the inconvenience with probates. So to the extent that you don't own immovable property within those jurisdictions, and probate is not mandatory, you are very comfortable. But where probates are required, if you want to avoid the inconvenience of a probate, a private trust is a way around it. Now, there are conditions which you can impose in a will, but those conditions are limited. If you look at the next point, directions as to application or enjoyment. When X gives property to Y and both of them are alive, it is called a transfer of property. What is essential, the most essential element of a transfer is volition. A transfer must be voluntary. Section 247 of the Income Tax Act deals with, why does 247 not apply to transmission? Because transmission does not involve volition of the parties. Another case of transmission is what happens upon death of a owner of the property. The succession is a case of transmission. Succession where it is made by a will, where X says that by a will he says that upon my death the property will go to Y. That is called a bequest that X makes in favor of Y of the property which is being bequeathed. The bequest may be made absolutely. I own immovable property located at so and so. Upon my death, the property shall be the absolute property of my son, Mr. So and so. This is an absolute bequest. A bequest may not be made absolute. I own immovable property at so and so where I am presently residing with my wife. Upon my death, the property shall be bequeathed to my daughter X, subject to the fact that my wife shall have a life interest in the property and shall be entitled to reside in it and use it for the duration of her life. In this case, the bequest to the daughter is not exactly absolute. In fact, it is absolute, but it is a bequest that occurs at a later time. You could also impose a condition. Let us say that I am the owner of the property. If X attains the age of majority, if the child X is also living right now, if there are any children of X who have attained the age of majority at the time of my demise, the property shall go to them. If not, it shall go to Y. This is a conditional bequest, where the bequest, who the bequest goes to is dependent on a condition, which is not known at the time of drawing up the will, but which will be determinable only upon the demise of the testator. The third category is where you say, I am bequeathing this property upon you, but you cannot sell it. I am bequeathing this property upon you, but you can only use it for these purposes. In these cases, unfortunately, there is no clear rule as to what extent these restrictions are permissible and to what extent they are impermissible. What the courts have broadly said is you must read the will sympathetically as a common person who has drafted that will would have drafted it. You should not look at it from the perspective of a lawyer attempting to interpret a statute and give undue weightage to particular expressions, and determine what is the intention of the testator. If the testator intended to give an absolute bequest, then any restraints imposed on that are void. If fundamentally the bequest is intended to be subject to certain restraints, then the restraints are valid. If you say, but then if there is an absolute restraint on transfer of the property, that is fundamentally void, because you are not in fact bequeathing the property to him, that ownership of that property is in a state of suspended animation. So therefore, in a will, the scope of the conditions that you can impose are somewhat more limited than what you can do by means of a trust. And therefore, in those situations, and these very rarely arise, you can use a private trust as an instrument. I recently had a case, maybe 6 months or a year ago, where there was a family who owned ancestral property in Gokarna. The younger members of the family were not interested in the management of the property. It is also a fairly large property. The family intended that the property be used for the purposes of performing, only for the purpose of performing religious functions, and also for the purpose of accommodation and all that which are incidental to those functions. They said that amongst the 20 people who are alive now, only 4 or 5 people are interested. And only 4 or 5 of them will actually take the burden. Everybody else is in a different country, they have demanding careers, etc. So in this situation, we recommended a private trust, because you can say that it is for the benefit of these people to conduct these functions. Or if you want that any member of the public be permitted to conduct these rituals at this premises, then it can be a public trust. Of course, it's a different matter that public trust may not be entitled to approval under ATG because it is for a religious purpose. But so these are certain use cases. These are use cases where you want, because of the nature of the property itself, you want to impose some restriction, and you are unable to find people who are willing to do it. You appoint these 5 willing people as trustees, and then things go on. Of course, if you have immovable property and you have uninterested family members, the pragmatic sort of very harsh advice is always to dispose of the property so that it doesn't, these days we find that property tends to sit heavily on the shoulders of the successors and people don't know how to deal with it. And that is often a burden. The second thing, yes.
In your previous statement, you said that if there is a restraint on the property in the transfer, but as per Transfer of Property Act, any such restraint on the use or the enjoyment of property, the transfer itself becomes void. Right?
Yes.
So then, how does the will become ambiguous in such situations?
You are saying there is ambiguity.
Because when you say that the property is bequeathed to someone, but that someone cannot sell it.
Yes.
Right. So that becomes void.
That would be void. That particular example would be void. So if you look at the provisions of the Transfer of Property Act, so first of all, it's not one section of the Transfer of Property Act or the Indian Succession Act which deals with this. Section 10, I believe, the Transfer of Property Act deals with one kind of restraint. So if you look at the Transfer of Property Act and the Succession Act parallelly, there are a lot of provisions which repeat. Rule against perpetuity is a classic example which you will find identically both in Transfer of Property Act and the Succession Act. But on this restraint specifically, not all the restrictions which are there in the transfer property act are there in the succession deed. So there are some restrictions which are there here. There are even more restrictions in the transfer property act. So it is not comparable. If you ask me to tell you which ones, honestly I don't remember. I will do that later on.
One more reason, the last thing would be that to avoid the inheritance tax also. If you have a private trust,
Yes.
one of the reason could be to avoid the inheritance tax.
The straight answer to that question is yes, but any legislative draftman worth his salt will ensure that the inheritance tax applies when you settle property upon trust for your own children. So that is a case of a special anti-avoidance rule in an inheritance tax. But yes, this is, and so I come to more cases which are similarly along the same lines as what you described. The next point is the difficulty in proving wills. See, a will comes into effect only when the person who has executed it, he is known as a testator. A will is known as a testament, and the person who executes a testament. A person who draws up a testament is the testator. Once the testator passes away, the will comes into effect. The person who ensures that the wishes of the testator are given effect to is called the executor, which is why testator, please don't say he executed the will, it's only confusing. If the person who is required to give effect to the will is named in the will, he is an executor. If there is nobody named in the will and the court appoints somebody, he is an administrator. If there is no will and the party dies intestate, court may still appoint an administrator for the estate of the deceased, even in the case of intestate succession. I will come to all of this later, but I just thought the language may be clarified now. So the difficulty in a will is that it comes into effect only when the testator has passed away. So the testator cannot come to the court and say, listen, I executed the will, it is correct. In the case of a trust deed, it comes into effect immediately. So to that extent, proving a trust deed is very easy. Proving a will is correspondingly difficult. In my practice, in our practice, we consistently advise that even if you have one piece of immovable property, even if all relationships between family members are very good, if you are able to afford it, please register it. The Indian Registration Act 1908 compels registration of certain documents, like section 16 and 17 if I remember correctly, but it also permits the registration of any document. You can register a love letter that you wrote to your high school girlfriend. There is no law that prohibits it. So, and of course, trust deeds are fairly regularly, wills are fairly regularly registered. I have myself, for my clients, registered a number of wills. The only inconvenience is going to the sub-registrar's office and all the incidental. I'm happy somebody said it, but not on the microphone.
But not only that, yes, but the will evolves over a period of time, right? The assets might change.
Yes.
And so you need to give register.
That has to be right. That's a very interesting question. The question posed is when the will tends to evolve over a period of time, assets may change, etc. What is the position there? First of all, a will may be revoked, amended, etc. by a fresh will. An amendment may also be done by means of a codicil. But typically, a well-drafted will is one that does not require amendment. So there must be a residuary clause saying all other property which I own at the time of my death, as expensive as possible, will be bequeathed in the following manner. So there are various ways to structure a will. If there is a lot of immovable property, then there should be one schedule each describing the immovable property. This is one option. I'm not saying that there is any compulsion. If you have 10 people you want to bequeath to, you want to bequeath to 2 jointly, 1 separately, 5 jointly, etc. Then it may make sense to say bequest category 1, so much percentage to A, so much percentage to B, etc. etc. Bequest category 2, so and so. And then make it simple and say this property will be subject to category 1, this property will be subject to category 2. So structuring a will and drafting a will is very important. In most situations, so for example, bank accounts. If you name the bank accounts in the will, and then you don't say that any money is in any bank accounts, tomorrow an FD matures and is renewed with a different number, to that extent the succession is intestate. So it is important to be specific. It is important to be not too specific also. This is the same advice we give in the context of charitable trusts. If you want 12A registration, the objects should be so specific that some future trustee doesn't leave the trust to go in some other direction. The object should be general enough that you are not unduly restricted tomorrow when you want your organization to evolve. So this drafting is very subjective and it is not. But where you have executed a registered will and subsequently you have revoked that will or modified it by a subsequent will or a codicil, again there is no compulsion to register that subsequent will or a codicil. But if you have registered the first one and you haven't registered the second one, and then there is some dispute, this will be a ground to challenge the existence of the second will. So at least notarizing. And when you notarize, you have to ensure that the notary enters it into his register. That is another point. We have a case of a high net worth individual who has drafted at least 4 wills in the last 5 years. Each will in favor of a different party. And so it will be in favor of X, Y, Z, and he said, no, I have made up with X, so the 4th will be in favor of X. He's a man who travels between India and abroad. He came to us with the 4th will 2 days before a flight abroad. So then he said, see, I don't have time to register it. So we recorded in the will that I am executing this will today. I have booked tickets to travel abroad tomorrow. Therefore, I am not able to register it now. I will notarize it. If I am able to register it upon my return, I will do it. And it was registered later. These narrations make things easier. So the one thing to remember is that a will is not to be drafted like a lawyer. It should be drafted like a common person, but it should be drafted with the intelligence of a lawyer to ensure that there are no ambiguities.
So I have a question linking both the trust and the will.
Yes.
If I am a beneficiary
Yes.
of a trust,
Yes.
can I, in my will, add
Yes.
that portion?
Beneficial interest. So beneficial interest in property, in trust property, is property in itself.
You are not the legal owner.
Yes, you are not.
So then I can still include it in the as well.
Absolutely. You will say my beneficial interest in this.
But if the trust is very clear that this is only for this beneficiary and not for anybody else, right? I mean, that's how.
So then the question is, if the trust is not revocable and the beneficiary dies, what happens to the trust property?
Right.
In that case, the Trust Act provides that if the trust becomes incapable of execution, or the object of the trust is exhausted, or the trust property is exhausted, then the property will be held in favor of the settler by the trustee. So that is called a resulting trust, where the trustee retains his character as a trustee, but holds it for the benefit of the settler instead of the beneficiary. So it depends on the terms of each trust. The question is that your first question as to whether the beneficial interest of a beneficiary in trust property is itself property, the answer is yes. But as you say, there could be terms in the trust deed that take away from that right, and that you will have to consider in the facts of each case. The only restriction in respect of beneficial interest which the Trust Act itself imposes is that you cannot make that the subject of a further trust. You cannot say that I am the beneficiary of such and such trust and I have beneficial interest in this microphone. I hereby act as a trustee and settle my beneficial interest in favor of another beneficiary. That is not possible. Every time a question is asked, it feels like an exam. I start talking and then I find that I'm on the right track and I end up in the right way and everybody is satisfied. In fact, the only difficulty is if I am convinced and you are convinced, we don't know whether I'm right.
These questions are coming up,
Yeah, that is the intention, then at least I'm doing my job to some extent.
So the registration of will is guided by in Karnataka by the Karnataka Stamp Act.
That's another interesting question for various reasons which you have not contemplated. The law of stamps and the law of registration are administered by the same authority, but they are two different acts. Indian Registration Act is a parliamentary enactment which governs registration of documents. Whether you have to pay stamp duty thereon is governed by the Karnataka Stamp Act. Registration of a trust deed is necessary. Registration of a will is not mandatory at all.
If it is registered,
Under the Registration Act,
the stamp.
there is no stamp duty on this. I mean, that is if you think about it at a policy level, all I'm doing is dying and giving my property to somebody else. You can't possibly impose a stamp duty on that. And there's another reason for that. I like this seminar because I'm permitted to go into all kinds of theoretical circumstances which I would not have otherwise had the liberty to do. This is why I prefer speaking to giving a professional advice, because in professional advice, if the question is asked, I have to go only on that track. If I'm tempted to go down a tangent, I can't. So there are two categories of wills: privileged wills and unprivileged wills. Most of us will never see an unprivileged will in our lives. A privileged will, which is what all of us will see, the requirements of a privileged will, and this does not apply to Muslims. A Muslim will is known as a wasiyat, and a wasiyat is not subject to the requirements of the Indian Succession Act in respect of drafting and execution, not execution, drawing up of wills. So in the case of a will drawn up by any person other than a Muslim, there are two requirements. One, it must be in writing, and one, it must be attested to by two witnesses. If these two requirements are satisfied, an unprivileged will is valid. There is another kind of will called a privileged will, where there is a soldier in combat and he is killed on the battlefield, or he is sustained grievous injury or anything of that sort. His will can even be over. There is no requirement for writing or two witnesses. So theoretically, a will can also be over, albeit in one restricted case. How can you impose stamp duty on an over will? You can only impose stamp duty on a document. I have one more theoretical point. Please stop me if I'm going too much beyond the syllabus. Why is stamp duty? What is the difference between a tax, cess, surcharge, duty, impost? Impost is the widest possible expression. It is that which is imposed. All of these are mandatory exactions by the state from the person. Something is said to be a tax, and there's no written rules on this. This is just how the laws are. Something is said to be a tax when the subject of that tax is an action or an event. Goods and services tax is a tax on supply. It is not a tax on goods and services. Excise duty is a tax on goods. Customs duty is a tax on goods. The taxable event may be importation or manufacture, but the duty is chargeable on the goods. But GST is chargeable on the supply. Income tax is chargeable on income, which is an event. So stamp duty is chargeable on a document. That is why it is a duty and not a tax. A cess is an impost which is mandated by law to be used for a particular purpose, health and education. A surcharge is an impost which is computed on another impost. Which is why education cess, secondary higher education cess is not actually, if you look at the Finance Act, it's not called a cess. It is called a surcharge. Or it's called additional surcharge in some cases. So that is the education and higher secondary education cesses and all that are cesses in the nature of surcharge. Because they are imposed as a percentage of another tax. You may have a cess in the nature of a tax, such as the R&D cess which used to be there at least before the time I started practice. Estate duty is a duty on an estate. Now, the other use case for the settlement of property on trust is where you want to exclude the application of certain personal laws. The Shariat laws are a very useful example in this context. There are various communities within Islam, but two primary communities are Sunnis and Shias. The Sunni law and the Shia law are considerably different from each other. If you look at their succession law, so if you look at Hindu succession law, where there is no will, that is intestate succession, in the case of a male, in the schedule to the Hindu Succession Act, there is class 1 heir, class 2 heirs, cognates, agnates and cognates. In the case of a Hindu female, sections 15, etc., list that these are the heirs. Typically what those provisions say is that in this category everybody will get equally. Or it will say in this category if there is one person he will get fully and the rest will get nothing. Broadly this is how it works. Islamic personal law or Shariat is not like this. Shariat says for each person there is a fixed percentage. And sometimes, and I don't want to go into this in detail honestly because I did not understand it in detail. Hopefully I'll get some intestate succession matter of a Muslim to understand it better. sometimes you will find that when you work out all the percentages and fractions, you will arrive at an improper fraction. That is where the numerator is higher than the denominator. So it is extraordinarily confusing. And so this is one dimension. Now the powers of a Muslim under the Shariat law to dispose of property by means of a will are also limited. So I have it noted down here somewhere, but if you want it specifically, I'll tell you. But between Sunnis and Shias, in one case, so 1/3 of the property is one thing, which is drawn in the Sharia law. In one case, up to 1/3 you can make bequest by will. If you have to make bequest of the remaining 2/3, you need the consent of all the heirs who would have taken that 2/3. And in the other case, you need consent even for the 1/3. So if you want to do all of this, if you want to avoid all of this, you can settle property upon trust. Typically what Muslims do in practice is they gift much of their immovable property to their children, etc., much before their death to prevent all these complications from arising. And of course the oral gift hiba is also permitted but problematic in matters of questioning title later. Now trusts and wills are not mutually exclusive. You can create a trust by a will. You can say that upon my death, this property shall be held in trust by me for the benefit of me. You can put a whole trust deed in your will. There are as many terms as you want. Although trust deed can certainly be just one sentence, as I have shown in various examples. In fact, there are very many examples of, so for example, if you look at the judgment of the Supreme Court in Aditanar Educational Society, that dealt with the interpretation of section 11(4)A of the Income Tax Act of, which is, businesses which are held as trust property. If you look at that particular trust, that relates to the Tamil magazine Dinatharthi. There the newspaper was being run as a business, but it was run by a trust, the object of which is the promotion of education. Therefore, all the profits of the newspaper were to be applied for educational purposes, and it got registration as an educational organization under, I don't know, 12A, 12AA, I don't remember. That was a trust actually settled by a will. So it is not necessary that so it is also permissible to settle a trust by a will. Now, probate, broadly I have dealt with. Probates, so this territorial application is also only for Hindus, Christians and Parsis. In the case of Mohammedans or Muslims, as I have said, their wills are called wasiyat and they are not governed by the Indian Succession Act's provisions relating to wills at all. Probates also therefore do not apply. Probates, so who can file an application for a probate? The Indian Succession Act says that a probate can be granted to the executor of the will or to any beneficiary under the will. So somebody who is entitled to take out of the estate of the deceased from the will. And so this is what typically the court prefers. If there is an executor, probate will be granted to him. If there is a beneficiary, probate will be granted to him. Otherwise, probate will be granted to a creditor who is entitled to take from the estate of the deceased, or to any other person who files an application. But where there is an executor, typically it is only the executor to whom a probate is granted. Now, what does a probate do? What does a succession certificate do? I'll come to the succession certificate in just a bit. Neither the probate nor the succession certificate deals with the title to the property which has been bequeathed. The effect of a probate is only to say that the will existed and that if the executor named in the will has performed certain actions, those are valid because the will has, we have said that the will exists. Tomorrow, if a title suit is instituted in respect of some immovable property which was the subject matter of the will, the fact that the probate was granted will not affect the result of the title suit because the court in that proceeding will have to examine what is the actual title to that property. In a probate proceeding, the court will simply not go into that at all. The position in respect of succession certificates is similar. before I come to succession certificates, I will deal with nominations. There is some considerable confusion on nominations. I have taken as an illustration section 45 ZA of the Banking Regulation Act, under which you name nominees. As I predicted, I don't think I'll be covering too much of the syllabus. Under which you name nominees for bank accounts. Let us read the subsection 2 of 45 ZA. Please don't read faster than we will have to break it up to be clear. Notwithstanding anything contained in any other law. So this subsection 2 of 45 ZA, you will find identical provisions in various laws. Section 109 of the Companies Act 1956, I don't remember the corresponding act of the 2013 section, which deals with nomination for shares. You will find the same provision. If you look at the Government Savings Certificates Act, under which the NSE were issued, that will also have the same provision. If you look at the Insurance Act 1938, that will also have, all these provisions are similar. Notwithstanding anything contained in any other law for the time being in force. This is very clear, you can safely ignore this. What is significant now is, or in any disposition, whether testamentary or otherwise, that means the provisions of subsection 2 will override a will. Because the provisions of subsection 2 are expressly overriding testamentary disposition of property. A testament is a will. Notwithstanding anything contained in any law of the time being in force or in any disposition, whether testamentary or otherwise, which means intestate succession also is overridden by the nomination. Please don't get scared. You will find out what it is overridden, what it overrides a little later. Notwithstanding anything contained in any other law for the time being in force, or in any disposition, whether testamentary or otherwise, in respect of such deposit. Subsection 1 says you can name a nominee for a deposit. So for that deposit for which nomination is named, where a nomination is made, a nomination made in the prescribed manner purports to confer on any person, the next words are crucial, the right to receive the amount of deposit from the banking company. It is very important to note that what is conferred by a nomination is only the right to receive the money. It is not ownership over the money. You receive the money. Notwithstanding anything contained in any law of the time being in force or in any disposition, whether testamentary or otherwise, in respect of such deposit, where a nomination made in the prescribed manner purports to confer on any person the right to receive the amount of the deposit from the banking company, the nominee shall. Most statutes you will find two parts to a section. The first part is what are the conditions for that provision to apply, and the second part is what are the consequences of the application. The nominee shall, on the death of the sole depositor, or as the case may be the death of all the depositors, become entitled to. So now the section is saying what are the nominee's rights. To all the rights of the sole depositor, or as the case may be of the depositors. Which means, if an FD was held by the testator T, and he has named a nominee as N, Mr. N as the nominee, the nominee is entitled to all of Mr. T's rights in respect of the deposit in relation to such deposit. So it is not all rights in respect of the monies in the deposit or of the ownership of those monies. It is only in relation to the deposit itself, which means what rights? Right to receive interest, right to have the deposit renewed as per the instructions already given to the bank, etc. To the exclusion of all other persons, unless the nomination is varied or cancelled in the prescribed manner. What is crucial here is that the nominee steps into the shoes of the testator or the deceased person. He does not step into the shoe of the legal heirs or the successors of that person. He gets the rights of the testator, he doesn't get the rights of the successor. So a nomination does not create ownership. It merely says that the nominee will receive the property. The purpose of nominations actually is to protect the bank. And that we will see in subsection 4. Payment by a banking company in accordance with the provisions of this section shall constitute a full discharge to the banking company of its liability in respect of the deposit, which means if a nominee is named, if T is the deceased person who held the deposit, N is the nominee, and S is the rightful successor to the property, the bank is obliged only to pay the money to N. If S tomorrow says that that is my money, and he names a bank a defendant in a suit, the bank will say, I have discharged it, subsection 4 of 45 ZA says that my role ends the moment I have transferred the money to the nominee. So it is for you, S, to obtain the money from N, the nominee, not from me, the bank. Which is what the proviso says. Provided that nothing contained in this subsection, that is subsection 4, shall affect, it is not effect, I copied it from something online, there must be a typo, affect the right or claim which any person, that is S, may have against the person to whom any payment is made, N, under this section. So, subsection 4 discharges the bank. Bank makes payment to N under the section, not the subsection. S cannot proceed against the bank, he can proceed only against the nominee. So, like a probate, nomination also does not confer title. It only confers a right to receive the property. Title will always be conferred only as per the laws of testamentary and intestate succession as applicable to each individual. And this is settled by at least 5 decisions of the Supreme Court. I have noted 5 because that is the amount of time that my associate had to find 5 cases. If she had more time, she would have found more cases. Amongst these, I am sure that the branch will say the PPT with you later, but amongst these, the case in Shakti Yesdani versus the third case, 157 taxman.com 364, that is fairly instructive. It deals with all the earlier case law in some respect. What is significant also is that each of these cases deal with nomination under a different law. One is under the Insurance Act, one is under the EPF laws, one is under the Banking Regulation Act, and so on. One is under the company. Shakti Yesdani is in fact a case under the Companies Act. Next is succession certificate. We will read the second point first, which I think by now we are all clear with. Succession certificate also does not determine title. First, succession certificate applies only for movable property. It does not apply to immovable property. A succession certificate is a certificate where the court says this person has applied to me saying that these are the debts which the deceased owed. I am the person who should have received those debts. Please certify this. The court will immediately publish the application for succession certificates, right? The court will publish a public notice saying this person died, these are the debts, these are some of his debts, and Mr. X claims to be entitled to receive them. The court is going to issue a certificate. If you have any objection, please file objections. It will either consider the objections, or if no objections are filed, it will issue a certificate. So, succession certificate A does not apply to movable property. B, it is typically valid only for a particular period of time. C, it may be issued only to a specific person. It may be issued only in respect of some debts. It may not be issued in respect of the whole of the movable property of the deceased also. Whatever you file an application for, it is only to that extent that the succession certificate will be issued. This is why, if you go to a bank without a will of a deceased person, the bank will say, give me a succession. There is this practice on legal heirship certificate. There is no such thing known to the law. The BBMP issues it willy-nilly. I understand that under some law which governs public servants in the government of Karnataka, there is a legal heirship certificate contemplated. But as we know in India, the law and practice are two very different things. So typically in respect of immovable property, if you want a khata transfer and there is no will, you will need to produce a family tree with an affidavit and all that. That procedure has no known foundation in law. The reason that the khata transfers happen on that basis is because the khata is also not evidence of ownership. So so long as people are not accountable, things will go on. And I'm not saying that the khata should be evidence of ownership. All the khata says is, I am the BBMP and I know that the person who has to pay property tax to me on this is this person. And in my books, it appears that he is the person liable to pay the tax. It doesn't mean that he is actually the owner. So, there is a lot more to cover, but broadly on the subjects of private trusts and succession, and how the two interact with each other. I have covered everything. There is certainly a lot more to cover which I trust will be of use to you. So I will go on with it for so long as I have time. In the meantime, if you have any questions at this stage or any stage, please. Yes.
Sir, can we dwell upon the practice opportunity available for chartered accountant with respect to trust and
Drafting both wills and trusts. In the context, so the question poses what is the practice opportunity available to chartered accountants in this context. So, advice on succession planning. So I will tell you the practice opportunities. Whether those constitute the practice of accountancy under the Chartered Accountants Act is something I leave to you to determine. I don't want to come here and say that CAs can carry out legal practice and get into trouble for that. But the areas where practice is possible in this context is drafting of wills, drafting of trust deeds, advising on what method of succession is to be applied, and where, I mean, typically clients who approach chartered accountants for these things, they are typically more wealthy than they are not wealthy. So inventorizing assets. The client themselves tend not to appreciate this until you actually do it for them. So, and advice how to go about succession. I think anybody who owns immovable property should draft a will. And if all you own is immovable property, a few bank balances and say one demat account and say, insurance policy, the task of drafting a will is fairly simple. And it ought to be done by it can be done by a chartered accountant, law permitting. The only point in this respect is there are 100 services online which now offer, drafting wills, etc. If you pay peanuts, you get monkeys. What is the law on conditional requests? This is not something that an online service is going to clarify for you very clearly. If there is a simple succession where there is one or sir's question about covering all the property in the will, this is another very significant thing where wills are typically poorly drafted. And also simple linguistic clarity. So many wills are drafted so badly that you are not even able to determine what is the intention of the testator. So on all these things, I think there is a significant scope for practice. The other thing, we have some very wise clients who, without our advice, when they were most parents in their 70s and 80s, I'm not saying whether it's justified or not, but they do not have faith in the ability of the children to manage their property. So we have some clients who have removed monies from everywhere, consolidated it in 2-3 deposits, so that it's simply easier to manage for somebody. And this inventorizing is more relevant for the beneficiary than it is for the successor than it is for the testator himself. To list these areas, they are actually fairly narrow. But the more you go into it, the better you draft wills, you will be able to appreciate the value that you add to a client. The difficult part is only getting the client to appreciate how much value you have added. But I suppose it is easier to do that here than in audit. Because in audit you are seen as a person who creates a problem. Here you are at least attempting to solve a problem.
Can we sign in the last page of the document?
Yes.
Drafted by so and so chartered accountant.
I don't want to answer that question because
Lawyers do that.
No, so that's because
Drafted by so and so advocate.
so I try not to do that. Why should I be associated?
Chartered accountants, I think we cannot do that.
No, so I don't know. This is why I said when sir put the question, I'm not sure on whether to what extent all of this is within and without the scope of practice of the profession of accountants. This is something on which our central council and institute would have already said something. So it is better to consult her. I don't want to answer the question. I'm not well positioned to answer. Yes.
Sir, I think one more area could be the taxation of private trusts. How do we tax and tax planning through private trusts apart from drafting?
Very broadly, I can tell you there is no scope for tax planning through private trusts.
Because of the highest marginal rate tax.
Well, no. So there are two kinds of trusts for the purpose of income tax, which is also in the common law: specific trusts and discretionary trusts. Section 160 to 164A, 166 of the Income Tax Act. A discretionary trust is a trust in which the share of each beneficiary is not known. So there are two questions. We have already, let me deal with this at some point. We have already seen that a trust is not a person. Under the Goods and Services Tax Act, if you see the definitions, in the definition of person, trust is included. There is no such inclusion in section 2, subsection 31 of the Income Tax Act which defines person. The fact that the Income Tax Act does not regard a trust as a person is also evidenced by sections 160 to 164, 164A, which deals with who is to be assessed in the case of a trust. That is the first question. Only two possible people can be assessed. One is the trustee, the other is the beneficiary. If there are multiple beneficiaries and you don't know the share of each beneficiary, how can you assess the beneficiary? You can't. So, where you do not know the share of each beneficiary, it is called a discretionary trust. A discretionary trust income is to be assessed necessarily in the hands of the trustee. Where a trust is not a discretionary trust, you have an option either to assess in the hands of the trustee or in the hands of the beneficiary. If the trust, in a discretionary trust, I think the tax is at the maximum marginal rate. And I also, if I remember correctly, if a trust carries on any business, then also it is at the maximum marginal rate. So if you look at trusts settled in favor of relatives as defined in 5627, although 5627 explanation, 5627 charge does not exist anymore, but the explanation is still there. Then the same exemptions there are there in the case of trusts also. There was earlier, at least before, many years before I began practice, an opportunity for tax planning in the context of private trusts, but at present, I don't see how you can do that. You see, tax planning is possible to the extent of basic exemption limits, splitting it up with more and more people. The administrative inconvenience and costs involved in that simply do not justify that. This is what used to be done with HUFs. Every property will be, I think there is a family in Gujarat called Sarabhai or something where you will see judgments of the Gujarat High Court there. That property, that family had something like 200 HUFs just to reduce tax liability. Those kinds of structures, to my knowledge, are not available today to that extent. But even if they are available, the benefits very often do not justify the costs. If I conduct a seminar on taxation on HUFs or taxation of private trusts, I will deal with this in greater detail because I will be better prepared. But taxation on HUFs, honestly, I don't want to deal with it because I am too young to be very familiar with the HUF law. It is another field of complications. Then, so all the examples we have dealt with in the context of trusts thus far are trusts which are settled with the intentions of parties. But trusts may also come into existence without parties intending there to be a trust. There is, so those are called implied trusts.